Ma'am has so much of experience. Ma'am is having in administration, in industry, as a consultancy. Ma'am also has worked as a Director General of HR in DRDO. Now, ma'am is in IIT Bombay. Professor. Ma'am has so many international publications. Ma'am has a vast experience. Dear all the participants, I would like to uh, suggest you please learn from ma'am. Please listen carefully, and we are really uh, lucky to have ma'am here today, to have here her talk. So let us start the session without wasting our time and ma'am's time. So please utilize this opportunity. Uh, Thank you, ma'am. Thank you very much for uh, joining the session. Now I will hand over the session to ma'am. Before that, I want our Dean, Chief R&D Coordinator, Sarveshwar Rao garu to speak few words and start the session. Sarveshwar Rao, sir.
Yeah. Good afternoon to you all. Good afternoon, madam. I'm very thankful to you for accepting my invitation, honoring my request, and for joining us this workshop and giving a resource talk on this international intellectual property rights and its management in for startups. So really, I was more thrilled when you accepted, because you can enlighten us about the intellectual property rights and their applications and some of the issues concerned the IPRs, and address us how to come out of some of the problems also where we encounter in during the process of applying for patents and all these things. So thank you very much once again, and I, on behalf of the chairman and vice chairman and director Dr. Sameeruddin Khan and other faculty of the our institution, welcome you and to enlighten us about this subject topic. And thank you very much, madam. I welcome you. Thank you very much.
Thank you, sir.
Thank you,
Ma'am,
Mr.
ma'am.
Sarveshwar
Now
Rao.
I hand over the session to you, ma'am. Please.
Yeah. Thank you, Mr. Sarveshwar Rao. First of all, I would like to convey my gratitude to Shri G. Panduranga Reddy, Chairman, Dr. Vibhav Reddy, Vice Chairman, Dr. Sameeruddin Khan, Director and Principal, Professor Javed, Head of ECE of Shri Dattha Institutions in Ibrahimpatnam. Before I start my talk, I would like to say that Ibrahimpatnam brings back a lot of lovely memories of beautiful rocks around Ibrahimpatnam. Me and my family is an avid rock lovers. We love to go on a rock walk. Had these been the normal times and not the times like today that we are reeling under the coronavirus, had it been the good old times, I would have been on your campus and I would have made it sure that at the end of the talk, we really go out and do a nice rock walk on the rocks around your college. I'm sure there must be many rocks around the college. So coming to today's topic, I will now start sharing my screen. Just give me a moment. While I do so, I really apologize okay, it is It is not allowing me to share. What is the problem? May I know, Professor Javid?
Javid sir.
No, ma'am, you can share. I will stop my screen. Now you try, ma'am.
Okay, fine. I will try again. It is asking me several questions which I don't like to answer. Okay. Okay, are you able to see my screen?
Yes,
Yeah,
ma'am.
yeah. It's
Yes, ma'am.
come.
We can
come.
see.
Yes,
Okay.
madam. It has come.
Yes, okay. So first I apologize with this electronic devices. I found that I had my computer had in between probably gone to sleep, and because of that all the connections were not turning out to be the way they should have been, and therefore there is some delay. I apologize for that. So today's we want to talk about introduction to intellectual property rights. I know that this workshop is towards preparing you for the startups, which is a very interesting procedure. But before you actually want to start a startup, you need something in your hands based on which you say that I'm going to start up. And it's not money. There are many who finance your startups, but you have to have a substance in your hand. You have to have what is called intellectual property right in your hands. Then only you can start off with the startup. So I thought it most appropriate that we talk about in detail what is intellectual property rights, and that's what is my plan today. I am willing to take questions, but in light of this somewhat delay that we have undergone, I request that I will take the questions at the end, so that the flow of my talk continues and we finish within the given time, because is this customary to say that my time is being wasted, but I personally feel that it is the students' time which is actually being wasted, so I don't want to do that. So today I'm going to talk on these lines. I want to answer some of the questions, such as what are IPRs? What is the nature of IPR? What is the history behind today's IPR? What are patents in this whole IPR business? What are inventions that are patentable and what are inventions that are not patentable? What are the terms of patenting? What is a patent application? How do you go about filing the patent application? Generally, how much time does it take? Generally, how much money does it require? So all this information I wish to give you in today's talk. One may feel that there are variety of IPRs people talk. Why am I going to talk more about patents? Because you will realize that except for patents and copyrights, all other intellectual property come at a later stage when you actually productionize it. But the initial stage, what you need is patents or copyrights. Why copyrights, particularly in India? That also I will talk. So let us move on. What are IPRs? IPRs are generally legal and institutional devices to protect creation of the mind. Creation of the mind. This could be, a work of art. It could be a work of art. It could be a technological invention. It could be a design of certain equipment. It could be a tangible thing. It could be an intangible thing. They are all such things which are intangibles, until they are converted into a tangible form. They all have a possibility of converting itself into a tangible form, but by and large, there are certain disturbances coming. May I request everyone to switch off their mic, please? May I request all of you to switch off the mic? There is a lot of disturbance coming. Thank you. So what I was saying is that IPRs are the legal and institutional devices. While institutional rights, so legal device is very obvious. Why is it an institutional device? We will see when we go more into details of it. Sometimes they are tangible. So if it is a work of art, it is a book written, it is a picture drawn, it is a photograph taken. These are all tangibles. While there could be things which are designs which are not really tangible, or it may be an idea which is not tangible, but it can be converted into a tangible form. So it could be all the intangibles when converted into tangible form. All such things are called intellectual properties. It also includes marks on the product to indicate their difference from the similar competitive products. Okay. Now, IPR concept, if you go more into detail, it includes variety of forms. The first and foremost is patents, then comes copyrights, then comes industrial designs, comes trademarks, trade secrets, plant breeders' rights, geographical indications, layout designs of an integrated circuits, and control of anti-competitive practices in contractual licenses. This is rather too big a variety. I agree. Patents, I believe you have some idea, and we are going to talk in great details. Copyrights also, if you are a book reader, you would have known what is copyright. There is a small C around which there is a circle. It is a sign of a copyright. And generally, copyrights are given to the writer of the book. If you have translated the book, you have to take rights from the author of the book to translate it, and then you have partial rights, copyrights on the book. The difference between patents and copyrights is that for patents, you have to apply. For copyrights, it is not necessary to apply. Any literary work that has been documented in a proper fashion with a date and time very clearly given becomes a copyrighted material. Okay. What is industrial design? For example, one of you, while working in your engineering course, you suddenly get an idea that if actually I design a certain equipment in a way so that it becomes compact and it becomes much user-friendly, these are called industrial design. So for example, in the olden times, you can see that the design of a typewriter or design of a keyboard of your computer or design of your laptop, these are all industrial designs. And this industrial design, once conceptualized by a person, he or she can have a right over it. Trademarks. Okay. Coca-Cola, written the way it is written, it is called a trademark. Okay. McDonald's, the big M in a red color and a yellow color. This color combination, the kind of M is written, this is called a trademark. There are two kinds of trademarks, registered trademarks and there are unregistered trademarks. When the time will come, you will know what is what. But when there is a registered trademark, generally it has a small R symbol in superscript with a circle around it. That is called a registered trademark. Otherwise, it is just called a trademark. There is also something called a service mark. because these days we provide a lot of services. Software industry, what does it provide? It provides the services. So there is also called a service mark, and that is generally represented by a small SM with a circle on it, again kept as a superscript on the symbol that is being marked, that is being used. Then there is something called trade secrets. You see, you can say many things in patent, but there is something that you are holding back, which is a key to it. How that patent works, that is called a trade secret. So you have trade secrets. Then if you are a plant breeder and you have discovered a variety of plant, a variety of seed, which will give you better plant, better yield of a plant, that is called a plant breeder's right. So the one who has done this research, this discovery or this research has a right over it. Geographical indications. Geographical indication has a lot of implication in India, particularly where you are coming from, Telangana. Geographical indication says that there is a particular item. It could be a design, it could be a product, it could be an agricultural product. This particular item is being designed and produced simply because of the typical geographical conditions available in that area, then it becomes a geographical indication. For example, Darjeeling tea is a geographical indication because it is the weather conditions in Darjeeling, the slope of the hills on the Darjeeling, and the kind of water flow that it gets. All these things put together makes Darjeeling tea a very special tea. So that becomes a geographic indication. It means that I may grow tea in Kerala as we do, but I can't call it a Darjeeling tea. Darjeeling tea has to be grown in that particular area. So if you register yourself and prove yourself that this particular product is being made in this geographical region because it has these conditions built into it, and therefore it comes out the way it comes out with these qualities, then it is called a geographical indication. Basmati rice is a geographical indication. Now, in Telangana, the Pochampalli Ikkat is a geographical indication. In Andhra Pradesh, Kondapalli wooden toys is a geographical indication, and we have got, India has got the right for this Pochampalli Ikkat, and for Kondapalli toys, it has got a geographical indication. It has been shown with respect to with respect to Pochampalli Ikkat that it is the place, the weather condition, the availability of colors, the kind of acidity and basicity of the water, everything put together gives this kind of colors and weaving pattern, and therefore it is a geographical indication. Geographical indications, once recognized, they apply all over the world. So you once it is a Pochampalli Ikkat or a Darjeeling tea, it applies to India, it applies to USA, it applies to England, it applies to China, whatever you say, it applies everywhere. The layout designs for integrated circuits, it's very simple, because integrated circuits, you know that the way you make the layout, you can make it more and more compact, and you can make, I mean, from the huge computers, we came down to today's laptop, and finally we have come to what is known as our mobile phones. These all have come through the layout of integrated circuits, and therefore that is also a intellectual property. Control of anti-competitive practices in contractual license also makes a part of IPR concept, because as we will see in future, IPR is there to make use of the invention, the innovation for the good of public. And while doing so, if the inventor or the holder of the IPR or the intellectual property rights puts on unnatural conditions on the person who is a licensee to this technology, licensee to this innovation, that is also incorrect. It's against the spirit of the fundamental idea of intellectual property rights, and therefore that is also part of it. Why do we have this? What is the rationale behind it? It provides an incentive to the creator of knowledge. If I create a knowledge and I convert it into a public good, and if I can produce it, or I can give a license for someone else to produce it, so that public is benefited, and in turn I am benefited by getting the license fee or royalty. So there is a financial benefit involved, which encourages the individual who is creative enough, who has a knowledge, to provide things or specialties for public good. Okay, so it provides an incentive to the creators of knowledge. Second thing, knowledge has a character for a public good. It means that it encourages such knowledge which has an application towards public good. It can be used repeatedly, for which the user incurs little cost. I can use it repeatedly. Today, I am able to use this computer. I am using a laptop. You are using a laptop. We are all able to use it simply because someone has patented it, and somewhere the part of this sale money goes to him. You don't have to even think of this computers. Even, in the sewing machine, there is a needle. In the sewing machine, there is a needle. And this needle design itself was a patented design. So for a certain period of time, the person who designed it got the royalty, but it did so much of public good. Today, we are all wearing stitched clothes, and that comes out of those machines. It establishes a system through which the interest of the creator and the public can be balanced. So if I create something and someone else starts producing it and I get nothing out of it, my interest in creating anything will evaporate. I will not be interested. But if the same thing can be used for the public good and I get some earning out of it, it is good for me, it encourages me, it is an incentive for me, and therefore I do it. And therefore this whole idea of intellectual property right came. IPRs are a monopoly right. It is my IPR. It remains mine, but I license it out to others for producing it. I myself may produce it. I'm allowed to produce it myself, but at the same time, I can license it out to others, but it remains my monopoly. That remains mine for 20 years. Okay? So IPRs are monopoly rights. It usually talks about a new and original knowledge. The run-of-the-mill, we will see it in future that, just do a mixture of few things and make something, that's not IPR. It is a very new and original knowledge. IPR is given for a fixed term. Okay, except trademark and copyrights are given for almost a lifetime. though copyright also has a limitation. Geographical indications are for lifetime. Geographical indications are for lifetime. It can have indefinite time. Trademarks can have indefinite time. Many others, you can renew it after its lifetime, but they have a fixed term. All of them have a fixed term. Copyright is more or less the lifetime of the author, because once it is published for 60 years, it is 60 years after passing away of the author, it remains with the author. So suppose I write a book, okay, then I have a right to this book for my lifetime. It's my copyright for my lifetime. I don't have to pay anything for it. I don't have to renew anything. Even if after I pass away, after my death, I can give my rights to, just like I give my property in a will, or I can, I can distribute the gold according to my will. I can will it out to someone, but it can remain so only for 60 years after my passing away. Okay, so this is for the copyrights. Again, I say all IPRs have fixed term, except for trademark and geographical indications, and copyrights have a very special structure. Otherwise, IPR have to be renewed from time to time for keeping them enforced, except in the case of copyright and trade secrets. Copyrights and trade secrets, you have to do nothing. It remains with you forever. But otherwise, you have to renew it from time to time. IPR are largely territorial. Now, this is something you must understand. Intellectual property right is by and large, except actually for copyright, it is territorial. So if I take an IPR, if I take a patent in India, it is applicable only to India. If I take a patent in USA, it is applicable only to the USA. Okay, so IPR are territorial rights, except for copyright, which is a global right. Now remember, there is nothing called an international patent. Please remember it. This word will be used and you may come across it in future. But remember that there is nothing called international intellectual property right or international patent. There is nothing like it. Only copyright is global. Rabindranath Tagore's literature is a literature for everybody, or Anil Adiga, whatever he has written, it is the world over, it applies. Even if the literature written in the local language, the copyright applies world over. It's a global right, but that's not the case with other IPRs. They are territorial rights. It can be held by any legal entity, the one who has a right to sell and purchase. The person who has a right to sell and purchase a property has a right to have an intellectual property right. It can be assigned just like any other property. It can be assigned, it can be gifted, it can be sold, it can be licensed like any other property. This is perhaps the only right which can be simultaneously enjoyed in more than one country. How is that? Okay, there is no international patent, but I can have the same invention patented in India and a few countries abroad. I can have a patent in India, in UK, in France, and in USA. And in all these three places, all these four places, the patent law of that country will apply, and accordingly you can enjoy the rights of it by licensing it out in those countries. So that is why it says that it is perhaps the only right which can be simultaneously enjoyed in more than one country. You see, you have one property in India, you can't enjoy it in USA. You have some gold where you can wear it in USA, etc., but it doesn't have the same feeling. Here is the one property which you can simultaneously enjoy. At the same time, you can enjoy in more than one country. Okay. The question is, when did this intellectual property right came into being? The record shows as far back as the 14th century. In 1332, in Venice, the council gave a special privilege to a foreign constructor of windmill. There was a foreign constructor who knew how to make a windmill, but he won't part with his knowledge. And the Venetian council felt that it was getting deprived of certain advantages of having this windmill. So they gave him special privileges to construct the windmill in Venice. This is the first of its kind where it has given a patenting right, a property right, intellectual property right. In 1416, the record says that a council awarded a patent to one Francis Petrie from island of Rhodes for a superior device to shrinking and thickening of fabrics. And that right was given for 50 years. The thought of public disclosure came about in 1421 when Brunelleschi in Florence, which is called Florentine, was awarded a patent to build a new ship. Initially, he didn't want to part with his knowledge of how to build a ship, but he was given a kind of a reward for making a public disclosure. He was given a reward to make a public disclosure and were given exclusive rights for making and marketing it. Apart from this, in different countries, the patent rights came in different ways. The Venetian case we saw just now, the first patent case was filed against them. You know, now you are getting into a legal battle. That happened in 1602. It came about as a statute for monopolies in the United Kingdom in 1623. In our country, it was in 1856 that the first Indian patent system was put into place. The Patent Act, Indian Patent Act, was made in 1970, and the amendment came in 2005. On the other hand, as I said, these patents have some international nature, right? Because when we do the trade, when we do the trading of goods, we can also trade the technology. And when such trades take place, you need to have certain obligations to meet for the intellectual property rights. And these activities started as back as in 1873, where what happened was that in the royals of Norwegian and Austrian Norwegian region, they were holding an exhibition of new inventions. The idea was that people come to know what are the new inventions and how it can be best used for public good. Where it was found that mighty countries like UK, France, Italy, etc., they declared a non-participation in international exhibition of inventions. And why they did that? Because they felt that they are not very well protected. And that gave it initiated a process of giving intellectual property protection to people who come from other countries in your country. Then how to do it? Because every country has their own laws, their own ways of doing it. So there came into being what is known today as Paris Convention. This looks after patents and trademarks and such intellectual property rights. While in 1886, I mean, this all are the fallout of this non-participation. These were the fallouts of the non-participation. And then there came a Berne Convention which talked about copyrights. These two institutions, bureau, the offices which were working on, settling these issues and finding a way which is, acceptable to more than one country who is participating in this convention, came about what is known as United International Bureau for Protection of IP. If it is written in French, its short form would have been BIPRI. So it is BIRPI, which came into being in 1893. As the trade increases, in 1947, from BIRPI came a general agreement on trades and tariffs. From that, the time went on. The World International Property Organization came into picture. The Patent Cooperation Treaty came. The CEC Patent Cooperation Treaty, or PCT, is a wonderful device to get a priority date over the patent application in different countries at the same time. Then finally, BIRPI was merged with WIPO, that is World International Property Organization. Then European Patent Office was set up. US Patent Office was set up. A Uruguay round on the, establishing a general agreement within the WIPO convention took place. And finally, World Trade Organization was established. But all these are starting in order to protect the intellectual property right of a citizen of the world, make their life easy and make it straightforward. Now, as I said, there are so many varieties of intellectual property rights. But for startup, as I said, there will be people to finance you, provided you have a strong intellectual property with you. And this intellectual property that you can show to anybody comes in the form of patent. And therefore, now onwards, I'm going to talk mainly about the patents. What is a patent? It is a right awarded by a country for exclusive use of invention for a limited period and applicable within the country. Remember, it is a territorial right. So the country gives you an exclusive use of invention for a limited period of time and within the boundaries of that country. In the return, inventor has to disclose his invention to the public. The inventor has to say what is it that he has invented. So this is give and take. The country gives you a right to exclusively use your invention for a limited period and within the country, but in turn the inventor has to give away his invention in the public domain. What can be patented? Actually, it's very interesting. The definition of patentability or the criteria of patentability is very limited, but it is better defined by what cannot be patented. And you will see that there is a long list of things that you cannot patent. Okay. So what is the patentability criteria? A product or a process qualifies for a grant of a patent if it satisfies 3 criteria. Okay. The novelty, non-obviousness, and usefulness. Okay. Novelty, what is it? Not a part of state of art. It is not part of what is existing today as a latest state of art, meaning latest research or latest invention. It is something beyond that. It is something novel about it. State of art comprises of product, process, information in public domain. So whatever is available in public domain, within that, you have to show that what you are trying to patent is novel. Non-obviousness. A person who is expert in this area where you are showing that this is my invention is a novel. A person who is skilled in that art should not be able to see it as an obvious thing. Okay. So non-obvious to the person skilled in the art. And remember, it is not governed by the quality or the quantity of the inventive step. Quality or quantity does not matter. It has to be a novel. It could be a tiny little thing which no one could obviously think about. Then it is a novelty. It could be a very big thing. Doesn't matter. The novelty has to be non-obvious to the person skilled in the art, and it does not matter whether it is a tiny little thing or a very big thing. The size, quality, or the smallness of the inventive step is not a criteria. Now I come to the point. So what is not patentable, that actually defines what can be patentable. Okay. So an invention which is frivolous or which claims anything obvious contrary to the well-established natural laws. Someone comes and says that हवा में हाथ करके सोना निकालूंगा, that cannot be a patentable invention. Which anything obviously contrary to the established natural laws, if you talk of, it is not patentable. An invention, the primary or the intended use of this invention should not be contrary to the law or morality or injurious to the public health. You shouldn't be bringing out something which is of the society. It cannot be against the law. It cannot be breaking the law. So these inventions are not patentable. A mere discovery of scientific principle or a formulation of abstract theory is not patentable. So Einstein's E is equal to mc square is not patentable, because it's only a mere discovery of a theory, and therefore that is not patentable. If you just find out a new property of an existing material or a new use of an existing substance, or you already know some process and you say that, I can use this process and make something new, that is not patentable. That is not novelty. That is not novelty. So it is not patentable. If you just take the two substances and you mix it, you take two machines and you rearrange that their circuit in such a way that the properties or what it gives is just an aggregation of what the two can give, that is also not patentable. Okay. Mere arrangement or rearrangement of duplication of a device which is already functioning independently of one another in a known way is not a patentable. So you cannot say that instead, in this apparatus, instead of having a meter here, if I put a meter in the backside and another equipment in the front, it will give you a better result. It may give you better result, no doubt. No one is doubting it. No one is questioning it, but it is not patentable. Okay. A method for testing applicability during the manufacture, rendering a machine, apparatus, or other equipment more efficient or improve the restoration of existing machine apparatus is not patentable. You just simply do something so that it becomes, the machine becomes more efficient, it gives you more productivity. That is not patentable. That's not novelty. Any invention related to atomic energy is not patentable. Okay? So some decisions, what is patentable and what is not patentable, has something to do with the geopolitical situation as well as the lethality of that invention. A mathematical or business process or a computer program per se, or a literally dramatic or artistic work, or any other aesthetic creation, or anything which is cinematographic is not patentable. In India, computer software is not patentable. It is patentable in United States, but in India, it is not patentable. The computer software in India has what is known as copyright. It has what is known as copyright. Mere scheme or rule of performing mental act is not patentable. Okay. Or a playing game. So if you decide that if you do yogasana in this particular order, you will be benefited. No one doubts it. You will be benefited. But that is not patentable. If you do perform a yogasanas, or you perform certain exercises in this order in so many times for so many days in a week, you will be, of course, benefited. Any exercise benefits a person, but it is not patentable. Remember that if invention is not patentable, does not mean that it is not useful. It may be useful, but it is just not patentable. Presentation of information. My this slide is not patentable. My slides, I can have a copyright, but I cannot have a patent. Okay. Topography of an integrated circuit is not patentable. It goes into a design. It is not patentable. Method, which in effect is a traditional knowledge, which is an aggregation or duplication of non-properties of traditionally known component or components, is not patentable. They go into, if properly defined, it can go into a geographical indication, but it is not patentable. Any method of agriculture or horticulture is not patentable. Plant breeders' right can be there, but it is not patentable. Any process of medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings or plants or animals, which eventually make them free of disease. It cures them of disease. It may increase their economic value, or it may increase its productivity in terms of plant. That is not patentable. Plants, animals in whole, or parts of them, or a other than microorganism, which include seeds, variety, species, biological processes of production and propagation of plants and animals, this is not patentable. There are other intellectual property rights that you may have, but you cannot have patent. Okay. So this is how the patents get defined. This is how the patents get defined. Okay. There are three types of patents that you can take in India. One is called a product patent, process patent, and product by process patent. By the way, let me add one thing. Whatever I defined so far, what is a patent and what is not patentable, this is with regard to the patent laws of India. Okay, I'm restricting myself within the patent laws of India. So that all that applies to an Indian patent law. Okay. There are three types of patent: product patent, process patent, and product by process patent. It means that If you have made, say, a good typewriter which has certain good qualities, that is a product patent. You can patent the typewriter itself. You can patent instead a process which eventually leads to a typewriter, that is called a process patent. And you can patent a product which is a typewriter which is made in such and such a way, which is called a product by process patent. All patents in India are valid for 20 years from the date of filing. Remember that with respect to patent, there are various dates. We will come to that. The date of filing, date of granting, date of examination, there are various dates, various stages. So it says that from date of filing, 20 years. This validity for 20 years doesn't come by itself. You have to renew it every year during the validity period. You have to pay certain fees, you have to fill up certain forms, you have to answer some of the questions, and then it gets renewed. So for 20 years, you have to keep renewing it 19 times. Okay. It lapses totally after 20 years or non-renewal of the patent. Maximum it can be renewed up to 20 years, then it lapses. What does it mean that it lapses? It means that the document that you have filed as a patent becomes a public property. Then anyone can use it and make that product without paying the license fee to the inventor. Means that the inventor has to make all his money that he has spent on invention and his intellectual property within 20 years. Okay. There are two types of patent specifications. One is called provisional, the other is called complete. If you file a provisional specification, within 12 months you have to file a complete specification. Patent specifications is something that you file in the patent office. So there are two kinds of patent specifications that you can file. One is called provisional, the other is called complete. If you file a provisional, you must file a complete one within 12 months. What are these? We will see. What is it that comes under a complete patent specification? Well, it has a very fixed format, title of the invention, field of the invention, use of the invention. Remember that unless it is useful, you can't patent it. It has to be a useful thing. So use of the invention. Prior art, what was there before? So that you can prove your novelty. What was there before? Prior art. What were the drawbacks? Where you found a place to have a novelty included. Comparison between prior art and the present invention. Whatever was available earlier and what you have invented, how it is new is what you show here. You summarize what is your present invention, then you make a statement of invention. What is the invention? You support it by detailed description of invention with drawing, working examples, everything you put together. And at the end, you put claims. This claims is the main thing. It's the legal term. If you want to, go to court and fight over a case that someone is illegally using my invention, then it is the claims which you are fighting for. So this is the most important part. What is prior art? To provide a definite direction for proving novelty and inventiveness. Right? What could be your prior art? The sources could be, the best sources are patents. Remember that patent is in open literature. It's always in open literature. It is in public knowledge. Only thing is, for 20 years, if you are renewing it, if anyone wants to use it, you have to pay the license fee. Otherwise, it is just information in public domain. So it could be patents, single unique source of technical information, earliest publication of invention, often only publication of invention, standard format presentation. These are the places where you can find the patents. Where do you search out these patents? So you can have any source of technical information, you know that you are doing this kind of work. So there are many professional bodies which publish such work on patents. The patent office has a patent search engines, so you can put in the keywords and find the prior art. In India, there is Ekaswa A and B. These are the two patent search engines which talks about all the patents filed in India. US Patent Office, European Patent Office, and WIPO Patent Office. These are also have a very huge database with a wonderful search engine where you can search for the patent. Remember one thing, that though the patent is a territorial right, but novelty is not territorial. Novelty and invention has to be global. If someone has patented the same thing in USA, you cannot patent that in India because there is no more novelty. Though when you get the right, that US person has a right only in the United States of America. But the novelty term applies here. Therefore, when you do the search for prior art, you have to look into patents world over. You can also have other non-patent literature such as journals where you publish the research papers, etc. So all of these come as a source of prior art. But very important thing to realize is that patent is a territorial right, agreed. But when you do the patent search, you have to do it globally. If the patent exists anywhere in the world, your idea of novelty or inventiveness is defeated. Your patent cannot be granted. Now, as I said, another most important part is a claim. It has to be defined very clearly with a precision, and the monopoly claimed so that others may know what exact boundaries of the invention within which they will be trespassers. Okay, this is a big statement. Let us try to understand it. It should be defined clearly. I think it's clear enough. It should be with precision. It is precise enough. Monopoly that you are claiming that this is my invention. So this my invention part has to have a clearly defined boundary, so that other person knows that if he does anything within this boundary, it will be infringement of this intellectual property right. Okay, so this has to be very clear. Now, as we move, you will understand. I can't see any one of you, but I can get the feel that this is getting confusing. So let us go into it. How do you write the claims? Okay, everything is a claim. It has to be precise. It has to be clear, and it has to define a boundary. So structure of the claim brings clarity, precision, and a boundary. So specification may contain more than one claim. Okay. All claims should be related to a single invention. You can have two types of claims. One is called an independent claim and the other is called a dependent claim. As the name says, independent claim does not refer to any claims of the preceding set or preceding listing. Each independent claim defines a complete invention in itself. So every claim, independent claim, defines an independent invention by itself. It defines its own boundaries. So here is where you have to define the boundary. We will go through an example so you know what do I mean by the boundary. It covers the basic and the broadest definition of invention. This basic and broadest definition gives the boundary. On the other hand, if you are looking at the dependent claim, they refer back to the preceding claim. Okay, what was done, what is an independent claim said? Based on that, you are further defining it, narrowing it down further on the subject matter, adding additional element, defining one more element. So this boundary, you are clearly clarifying it through dependent claim. Okay, now how do we write these claims? There are certain guidelines. Claim should conform to the invention as set forth in the remainder of the specification. That is very obvious. The terms used in the claim should find a clear support in antecedent basis of description. It means that you must define all the terms, technical terms that you are going to use, which may include short forms, which may include acronyms. All these should be defined prior to writing the claim. Okay. It cannot be a summary of any description. Claim is not a summary of description. See, again, just like a patent, what is a patent is better defined by what is not a patent. Similarly, here also sometimes what is claim is better defined by talking what is not a claim. Okay, so it says that a statement of claim should not be regarded as a part of summary or a description. The claim should not recite efficiency or the advantage of it. That's not the point. Whether the your invention has this advantages and that advantages, it is so much efficient. That's not what you are claiming. You are claiming a technical stuff, no qualitative thing. Each claim should be one continuous statement. One continuous statement. They should be numbered in Indo-Arabic number 1, 2, 3, 4, 5. And dependent claims should always group together with the claims that they refer to. Okay, now here I go to an example. Okay, so let me do that. I go back to my thing and I go here. Let us see. Yeah. Now here is an example that I came across in DMRN. We were trying to file a patent which is called a process for making near net shaped metal matrix composites. Okay, I was also new. I didn't know how to write the patent claims. So I and my colleagues did our best to write the claims. So we say that a relatively inexpensive process has been developed for making near net shaped composite components. Bad. Relatively inexpensive. This is not what you are claiming. You are claiming a technical invention. So the first claim doesn't talk about any technical specification except that we are making a near net shaped composite component where there is nothing new about it. Liquid phase sintering has been successfully developed and a viable technology for fabricating aluminum matrix composite components. Now again, we did not talk any technical terms. How did you do it? What was involved in it? We are all talking in a qualitative, in an expressive terms, but we are not talking the technology. Then we say that temperature and time for sintering have been optimized to obtain 100% density. That is also of no use. It doesn't say, what did you do? What was the optimized level? What are the boundaries within which you did fix the time and temperature to get your 100% density? That is not defined. So this is again a very qualitative claim. Uniformity has been achieved in the microstructure and mechanical properties, but what do you call uniform? What is the microstructure size? What are the mechanical properties? What properties were you expecting? What properties are good for it? What properties have you got? Nothing has been said. The mechanical properties are comparable to or better than the fabricated conventional method. That also doesn't give us any idea. So this claim is a mere repetition or a summary of the invention. Okay. Now you see, we went to a patent attorney and this is what we got. Now you see, it became 7 claims in a very beautiful way. It says that a process for making near net shaped metal matrix composite which comprises in steps of A, mixing aluminum and TIC powders to obtain a mix. So you know what material goes into it. Subjecting a mix to a step of cold compacting or set to obtain a compact. So you know what process are you using, and subjecting the compact to a step of liquid phase sintering. So here the first claim actually tells you what exactly have you done. Okay, so this is the invention by itself, that this is what you have done. Then I clarified in the dependent claim. You see, this is an independent claim. Here I make it a dependent claim where I say that a process as claimed in claim 1, this is claim 1, wherein aluminum and PICL are mixed by the step of dry blending. So instead of saying just a mix, I am giving more specifications to it. The process as claimed in claim 1, wherein the step of liquid phase sintering is carried out at temperature of 700 to 800 degrees centigrade. So you see, this makes it very clear that when you do the sintering, what temperatures are you using. The process as claimed in claim 1, wherein the step of sintering comprises in a first and second step of heating. The first step of second heating being carried out at a temperature lower than the second temperature of heating of 700 to 800 degrees centigrade. So it clarifies that you do it in 2 steps. The first step has a temperature lower than the second step, and the second step has this temperature. So it is slowly talking in technical terms. It is defining a boundary. You see, it says the first boundary is that it is a mix used by dry blending. Then it has a liquid phase sintering of 2 steps. The second step has this boundaries and the first step is lower than this. Process is claimed in claim 4. Now it's further, this dependent claim is further clarified, wherein the first step of heating is carried out in vacuum, then degassed. So it says how you do the liquid sintering, and the process as claimed in claim 1, wherein the step of SIP includes the step of degassing and the mix under degassing the mix under the vacuum. And finally, it says that the process of making near net shape metal matrix composite substantially as herein described and illustrated. This is the last claim. It says that this is how I make it. So you see the difference, what we said in the previous slide, which was a general story, and what we say now is very specific. So this is what is called claim, and this is where you can fight your legal battle if you feel that is necessary. Okay, so going back, this is how you have to write the claim. What happens if you are giving a provisional specifications? This was the complete specifications. In provisional specification, you just have to give description of the essential features of the invention. No need to give claims, no need to include any other manner of which performing the invention. You simply say that this is what, or rather what we had said earlier, that we are going to make a near net shaped metal matrix composite component, and that is it. But then within 12 months, you have to give the complete specification. What is the advantage of filing a provisional claim or provisional patent application, the day you file your provisional, that day becomes your day of filing. So after 1 year, you may file your complete claim, but your claim starts 1 year earlier. So your right, in case the patent is granted, your right is given to you 1 year earlier. Disclosure to the interested person for financial support. Once you have a provisional patent filed, you can go to a financier and say that, look, I have this patent. Within a year, I will file the complete claim. But in order to do that, in between research work, I need some financial support, and I get a product, and I may give you license the patent to you for actual productionization. So you please give me the financial support, or you can say that I will be able to return your financial support within so much period of time. It's a virtual extension of term of commercial exploration. You get 1 year time to explore whether your invention is commercially viable or not. If you feel within a year that it is not commercially viable, you need not file the claim, and your patent or provisional application already lapses. So there is nothing to lose. But you have a 1 year chance to find out whether it is viable, and your claim starts from the day you have filed a provisional patent application. Possibility of avoiding further expenses in case no commercial viability. That's what I said, that if there is no commercial viability, you can save the money. The patent applications are of two kinds. One is called ordinary, in which you file in a single country. In our country, the rule is that if you want to file anywhere else, you must file it in our country. I'm not sure if that has been relaxed. But generally in India, it is necessary that you first file in India, then you can file anywhere else. Or you can file simultaneously anywhere else, but you must file in India. So ordinary patent application is filed in a single country. A convention application files to several countries. If you first file in your own country, then within 12 months, you can file within the convention. There are two advantages. Your priority date remains that of the country if you are part of the convention. So that is an advantage. So your priority date remains same. If you go to each country separately and start filing the patent application, your cost will be much higher than you file it as a convention in a set of countries. This is called PCT, Patent Convention Treaty. So within Patent Convention Treaty, if you file in several countries, the cost is lower than filing to each individual countries. And your date of priority, when does your patent become valid? The day you have filed it in your own country, if you are filing within 12 months to this convention countries. Now, who files the patent? Who is the inventor and who is the owner? A big question. The one who has financed your invention becomes the owner of the patent, while the person who has actually done the scientific or technical work and worked out the invention remains an inventor. Sometimes the inventor and owners are same. But for example, suppose any one of you try to file a patent. It is the Shri Dattha educational institutions become the owner because they have spent money, given you the facility, given you the opportunity, the chemicals and what or not, all that they have provided. So they become the owner and you become the inventor. Or the person or organization who has bought the right. So suppose you are doing this you are doing a joint research. You are doing a research with by jointly with say DMRN. Then you must have had an understanding, a contract or a memorandum of understanding, and there it gets defined as to who is going to be the owner of the right. That person becomes the owner of the right. See, inventor, there is no doubt. The one who has done the invention is the inventor. But the owner is the person. It depends on who has financed it or what is your terms and condition if you are into a joint invention, joint program. How does patent procedure flow? The inventor, it goes to financier. Financier has to say yes. Then it goes to patent office. In between comes patent attorney. What patent attorney does is that what I showed you, what claims were written and what claims it turned out. So it looks into the proper legal terms. It puts your invention, the way it should be applied. So this happens between financier, inventor and the patent office. Then it goes to the patent office. There are 4 patent offices. You have to file in one of them. Then the next step comes. What happens within the patent office? There is a patent examination in the patent office. It examines the 3 aspects of patent: novelty, inventive step, and usefulness. Then it goes to, if it finds everything perfect, if it does not find, it goes back to the patent attorney, to you, to make the correction. It makes several such rounds. Once it is done, it goes for publication in official gazette for opposition. So then it makes the publication, and within the 4 months of publication, if anywhere in the world, and if anyone want to oppose, to say that this invention is already known, there is no novelty about it, there is no usefulness about it, there is no inventive step about it, on any of these 3 fronts, if it wants to defend, it can defend and say that this is not applicable. If there is no opposition, then the patent is granted. So either there is no opposition, or if the opposition is defeated, then the patent is granted. How much time does it take? Once it reaches patent office in the correct form and it gets publication in the gazette for opposition, I think it takes about 7 to 9 years. And from starting of, deciding to file the patent until the patent is granted, in India, it takes about 8 to 10 years. This time might have shrunk a bit, but not greatly, that much I can tell you. What happens in your institution, which is an educational institution, you have a research grant and you would like to make a publication out of the patent, then the rule is that once the patent is filed in the patent office, that it has gone to the patent examination stage, after 6 months, you can publish a paper. Okay. What is the fee structure? You can find this on the internet. In fact, to tell you the truth, I have designed this presentation in such a way that if you would pick the keywords and make your search on the internet, you will find a lot of information about how to patent, where to patent, who is a patent attorney, where you need to patent, etc., etc. Even this fee structure and many more other stages are given in that. So here I summarize my lecture at the end. We talked about intellectual property rights. What are they? Why do we have them? And what is the historical background? Then we talked about patents. What is patentability? It is better defined by saying what is not patentable. types and terms of patent, ordinary application, convention application, patent application structure, what is prior art and what are its claims, how to write the claims. Of course, once you have a patent attorney, they will help you out, but you will have to explain to them as to what is your invention, then only he can write. We talked about the time frame and we also talked about the fee structure. The whole purpose, while thanking you, I would like to say, the whole purpose of giving this lecture is largely to make you, to make you realize that the importance of intellectual property rights and patents, if at all you are thinking of starting a startup. Okay, because that's the basic right you must have before you can think about it. Number two, I have given you a very broad outline of what is patenting and how it is done. To many of you, it might be a first lecture on patenting and you might get confused. Please don't. There's no need to get confused. It is very straightforward procedure. I have given you the keywords. Use those keywords to do the internet search. Earlier, when I used to give these lectures, we didn't have such an internet connectivity or the internet information system, Google search, Bing search. We didn't have that. So this information had to be given in a certain format. But now if you know the basic terms of it, you can do the internet search and get the help. So these were my two purposes. I hope I have met them. And I stop my presentation here. I thank you all. I will go back to the, yeah. Okay, I don't think I have stopped presenting. Okay. Okay, I have stopped presenting. If you have any questions, I'll be more than happy to answer.
Hello.
Yeah,
participant.
No, ma'am.
Thank you very much, ma'am, for your beautiful presentation. Participants, if you have any doubts, you can ask to ma'am by unmuting yourself, or you can type in the chat box.
Chat box will be difficult. Okay, I'll see that. If you allow me, I just need a minute. My computer has suddenly gone down on battery. I'll just make a connection if you don't mind.
No issue, ma'am. If they type in the chat box also, I will recall. I will recall it, ma'am.
Sure. I'll be back in a minute. I just need to make the connection.
Sure. Sure, ma'am. Sure. Okay.
Javis sir. Hello.
Yeah.
No,
Yes,
Javis
sir.
sir, you're hearing me. And in the end, I'll tell few lines afterwards, once in the end,
Sir,
before
sure.
closure of the program. Okay? Just keep it in
Sure,
the mind.
sure,
Okay?
sir. Okay.
Right.
Okay, sir. Okay, sir. Sure.
Yes, I'm back. I'm sorry. Yeah, somebody was asking a question. Yeah.
Yeah, anybody can. Yeah.
Acha, there is some question here. Let me go
Yes.
to the chat
Yeah.
box.
How would I find a good
There is
patent?
How would I find a good patent attorney? Well, patent attorney, how you can find, I can tell you. First, you have to decide, I think because you are in Hyderabad, you have to patent it in Madras, in Chennai. Okay. And if you just search for a patent attorney in Hyderabad, you will find some. Now, good or bad, there is no ranking for them. Okay. So it becomes more or less a trial and error, but there are not many patent attorneys in Hyderabad as far as I know. And we, though being in Hyderabad as DMRL, but we were patenting because our patent rights, this you see, the owner of the patent used to be the DRDO headquarters in New Delhi. So our patent used to be filed in New Delhi. So there we used to go to Dastur and Company for filing a patent. That was our attorney. So I am not aware of any Hyderabad, but there are few attorneys in Hyderabad and you can try out. It's nothing like a bad attorney. All patent attorneys are good. They are all knowledgeable. It's a game of, making them understand technical terms. They are pretty good at it. They understand it very fast. You have to make it clear. It will work. That was Rajendran Vignesh. Then there is then how to get others patent and using their for our research. Yes, you can go to, you remember I had in my patent slide in prior art, I said that there is Ekaswa. Just type Ekaswa in Google and you will find an Indian Patent Office patent search engine, which is called Ekaswa. Or you can go to US patent search engine, USPTO or EPO in European Patent Office, or you can go to WIPO. They also have a patent search. In all these places, what you need is a keyword. Your invention has to have a keyword. For example, the example we took, it is a near net shape, is one of the keywords. Metal matrix composite is another keyword. So such keywords you must know that you want to research on or you already have an invention on. You enter those keywords and the list of patents will come. Then you can refine it further. So that is how you do your others patent. You can get patents from world over. With the internet, life is very easy and very beautiful. Okay, I think that's all. I don't see any other question here. Anybody else has any other question?
Yeah, anyone is having any doubts? Ma'am, I think there are no, okay, minimum time to complete full procedure for patent filing. This is the question.
Minimum time for to complete the full procedure of patent filing. Oh, well, if you have your invention and you have, see, even if you go to a patent attorney, your rough draft of patent application has to be ready. Okay, so it takes basically a time as to how good you write your, how good you have done your prior art search. Your prior art search has to be complete. And once that is complete and you have, shown each step very clearly, what is the novelty and what is an inventive step, if you have able to justify it and you take whatever claim the best you can write to the attorney. It depends within a month's time also, if you are very keen and your writing is very clear and you have a good, wavelength matching with the attorney, it won't take very long time to patent with the patent office. It may take a month or two maximum. Actually, patent attorneys are always in a hurry because patenting is all about time. Particularly if you are working on the state-of-the-art technology, then you would like to patent it as fast as possible so that no one else can come before you to file the patent. Remember, filing a patent anywhere in the world denies your novelty. So your patent right is within your country. Okay. Patenting is a kind of thing, that's the last thing I would like to say. It's like writing a computer program. Until you get into it, you never learn it. You may take as many courses as you like, but you really learn it by doing it. So I say that get into it, do it, and you will become better and better at it. Yeah. If two persons have submitted the same idea or related one in the same period, okay, this is a courtroom question. If you are so serious about your patenting, and if you are so much worried that, it is such a state of an art that there could be another person doing a similar work, you must have an excellent record of your everyday work that you have done towards that invention, with every evening signed by yourself and your supervisor. Then that could be a good evidence to say when you have done this work. If the other person has anything like that, then the dates and times are compared, and the one who has done it earlier gets the patent right, or gets a chance to apply for the patent. If the other person has not maintained any such thing, then you have the right. So it is a good idea to keep a record. If you think you are doing a research work which is of such an importance that you can take a patent, which you should. In that case, what you need to do is you have to keep a detailed record of what have you done, what results have you obtained, what was your procedure in the day. There must be a written record, preferably handwritten, signed by you and signed by your superior, who is a defined superior. You can't just take someone from the corridor and say that, hey, today you sign as my superior. No, that does not work. There is a hierarchy. So if you are reporting to someone who is your PhD supervisor, or he is your HOD, who is aware of this, you take both the signatures and store it. So when you go for patenting, and in case such a situation comes, you have to show this record, and whosoever has done it earlier gets the chance of filing the patent. If there is a time limit, then if we want to extend it, then what time limit I did not understand. There is only a nice ID number there, so I don't know who is this person. If there is a time limit, what time limit? To apply for a patent, there is no time limit. So maybe that person can come live and tell me as to what time limit he means. For some inventions. What do you mean by there is a time limit for some invention? You mean to say that this invention will be, there will be another invention which will invalidate? If you mean something like that, you have to just run. Patent expiry date is, as I told you, patent expiry is after 20 years, provided you renew it every year. Your patent expires definitely after 20 years, provided you renew it every year. The day you don't renew it, it becomes knowledge in public domain. Anyone can use it without giving any financial, without taking any license from you. For some invention, I still have not understood who is it. This is 18E41A0458. I have not, I think he is a ECE student, and I have not understood your question.
458. Can you unmute yourself and speak? What is your question exactly?
Dr. Javed, I feel if anybody wants to raise a question, let them unmute and talk. It will be easy instead of identifying the people and this. It's my humble request.
Okay.
Yes,
Sir,
yes, sir.
our directors of SM.
Oh.
Sir, good afternoon, sir.
Yes, yes. Yeah.
Sarveshwar Rao. Good afternoon,
Sir,
sir.
very good afternoon, sir, and
Good
very
afternoon, sir.
good afternoon to Dr. Hina Gokhale, madam. It's an honor, madam, to have you in this webinar. And I think our students are privileged to have such a person with such a giant stature addressing them. We
No
are very
giant
much
stature, sir. Everyone is of the same stature. We just got a chance to work. I'm sure your students will also have such opportunities in future.
let your blessings be there on them, madam, because the kind of area you are coming from with huge experience and knowledge, it's really, I think our students are blessed to have you here. And thanks to Sarveshwar Rao Garu for suggesting to have you in our panel, and you accepting our request in a short notice.
My
Thank you so
pleasure,
much.
sir.
Thank you so much, madam. On behalf of the management and all our principals and head of the departments, I once again thank you. And please accept one more request, madam. Kindly spare some time in future also to enlighten our faculty and students.
Sure, anytime, sir.
We'll feel blessed to have you. And in
My
fact,
pleasure.
I'll have a talk with you separately after this meeting also.
Sure.
Sarveshwar Agar was suggesting some other thing also. So
Sure.
we'll see
Certainly.
what. Thank you so much, madam. Thank you so much.
Most welcome, sir. Namaste.
Namaste, madam.
Okay.
Principal of. He is Dr. Sameeruddin, director and principal of our institution.
Yes. There was one question. Copyright expiry date. Copyright remains with the creator of copyright till the creator is alive and 60 years after that.
Good afternoon, ma'am.
Yes, please.
Actually, if suppose a copyright or a patent is valid for certain time, so we want to if we want to extend the time, so we have to apply it before the time ends or else after the time completed, ma'am, limit.
You cannot extend it. Full stop.
Okay, ma'am. Then after that, if the time ends, if someone created the same technology, so it is do the person get the same name?
He can use the technology and he need not pay anything to the inventor or the owner of the patent. He doesn't have to take a license.
Okay, ma'am.
See, very simple thing you imagine. Have you seen the Tetra Packs?
Yes,
You
ma'am.
get a juice in Tetra Packs.
Yes, ma'am.
You get a milk in Tetra Pack. Okay.
Yes, ma'am.
Now, these are the designs. These are not patents. These are designs. Now, you will find that two different type of companies who make Tetra Pak have different ways of opening it. Have you noticed it?
Yes, ma'am.
That's because it's one person's patent. He doesn't allow, he has found it the best way to open and serve it from the Tetra Pak. For example, to how to open the Tetra Pak and serve the milk. That is his right, and he will not, the other person, if he wants to use it, he has to license it from him. But if that right has expired, the time limit is beyond, anyone can use it. And they need not pay any license fee to the person who originally invented it.
Okay, ma'am. Thank you very much, ma'am.
Welcome.
Any more questions?
I don't
sir, I
see
think
any
we
question. Yeah, in the thing also.
can go ahead. Sir, you want to speak something, Sarveshwara, sir? You please go ahead, sir.
Yeah. Good evening, madam. It's an excellent presentation, eye-opening to our faculty and students about this IPR and their patenting and copyrights and all. It's a very crystal clear presentation. Even it remains in the minds, just like going to the inner part of the brain. They will be able to remember it. Mid of the night, if they ask them, they'll be able to tell it. That's what I feel. It's such a nice presentation.
Thank
And
you.
for the information of all attending this workshop and presentation, our workshop, I would like to mention that I'm proud to tell you that I had the opportunity of working under the guidance of Madam, and because of her blessings and support, I could reach this level, which I could not dream in my life. Thank you, Madam. I remember it forever. Thank you very much.
Thank you.
It's a wonderful, it's
So,
a good thing, sir.
So for 10 years, I was working under her guidelines, and really, she paved my path in the life to come to this level. Madam, I am grateful to you. Not only you and our sir also. Really, he has been supporting me in all the things. Her husband, Dr. Amul Gokhale, was the director of DMRL, retired director of DMRL. So he was also of great support to me, and really shown me how I have to be in my this thing career. Sir, Director sir,
Thank
you
you.
want to
Very
tell
kind of.
something?
Sir,
Sir,
Madam,
thanks
you
to
have
you.
any?
sir,
Sir,
I would like to invite our director, sir, to enlighten our students regarding these IPR events, so that the students and faculty can participate and they can do IPRs in the future. I want our director, sir, Dr. MD Sameeruddin Garu, to address the students and faculty, sir. With
The important aspect of the meeting I have already done. My main aim was to have an interaction with Madam and thank her personally. That I have done, and I once again thank her for being the resource person for an important topic like IPR. Madam, thank you so much. And our students are already enlightened students. You know, they are now enlightening the teachers. So I think now it has become a kind of necessary dimension to be started in every academia, where the faculty and the students should be oriented towards research and innovation. And IPR and information about IPR acts as a very important, information for the students and faculty both. I have been watching and observing our faculty taking keen interest in submitting their patents. I think 6 or 7 patents have already been submitted. But it was very much necessary for them to have the technical knowledge about IPRs. So hopefully, all our faculty who are attending this session might have got more than their expectations today. So my thanks to heartfelt thanks to Sarveshwara Garu, because we are again blessed to have him in our panel as a Dean R&D in our college. And after he has entered the scenario, he works every day. In fact, he is the youngster I have find in the entire team. He comes every day driving to the college, sits in the college, planning and trying to figure out how we can, take up this R&D activity in the college. So it is very, it's a privileged kind of, moment for me to proudly say that Sarveshwara Garu is with us. He has already invited the director of CITD, I think principal director of CITD. Week back, he visited our campus, and he also have expressed the idea of associating with our college and empowering the faculty and the students in the areas of mechanical engineering. So this is and he has referred very good profiles to be inducted as a faculty in our colleges. So I thank Sarveshwara Garu also, and I am really surprised to see the number of participants in this session today, because I was a little bit skeptical that IPR is something which requires that intellectual frequency to understand. But still, I could see a lot of students attending the session, and I can understand that how Madam has mesmerized them for these 2 hours. Otherwise, they don't stay for more than 20 minutes in the classroom. So that is a testimonial that the session might have done. I would request Javed Garu to please give me this recording. Tomorrow being Sunday, I can find time to listen to Madam and enlighten myself also. So I wish Javed Garu, who has done a tremendous job of organizing this webinar, and he has a couple of webinars in his plan. Probably in the coming weeks, he may be executing that. I request all the students and faculty to please be in touch with Javed and the kind of notifications he'll be sending to attend the remaining sessions also. And I request Madam and Sarveshwara Garu to kindly keep their support and blessing on our college in future also. And if required, I'll be directly talking to Sarveshwara Garu how we can meet Madam or talk to Madam personally to associate with our college. So thank you, students, and thank you, faculty. Keep the temperament of ideation, innovation, and research. Academicians particularly should not restrict themselves to reading the textbook and explaining the concept in the classroom. Teaching has become a very challenging job now, unlike the previous years. I am not trying to belittle the contribution of the teachers who have made us what we are, but the challenges that has come in the industry and the kind of demand for the talent in the industry has led to academia upgrade itself, and for that we require competent and passionate faculty to meet the challenges. So if a faculty has to reflect that research-based learning, activity-based learning, experiential learning in the classroom, then they need to have the temperament of research, the temperament of ideation and innovation. I know you all have come from a background where we also are from the same background of rote learning. Creativity has somewhere been suppressed in our schools. Ability to question has been suppressed long back. We need to revive all those abilities in us, and definitely we can expect good ideas from youngsters. So I wish that this seminar will act as a route map to all our faculty. I hope that it becomes a kind of initiation for many patents and many IPRs to come from our campus. So thank you so much, and I wish you students, I wish you all the best. Faculty, I wish you all the best. And thank you, Madam. Thank you, Sarveshwara Garu. Let us hope that we meet in future again. Thank you so much, Madam.
Thank you. Thank you very much for invitation.
Before the closure of this workshop, I have one thing to tell. We should have some way to have the long association of the eminent personalities like Dr. Hina, Gokhale, and other people. We can have some sort of tie-up with them. We had to explore the possibility and make some scheme under which we can be in touch with them, so that officially there will be some sort of thing we can create. It will be easy for us. What do you feel, sir?
In fact, I was directly or indirectly trying to convey the same thing to Madam, to kindly be a part of our advisory board or board of governors. That will be a great privilege, because if she can associate with us and contribute her advice and her guidance to us in how to bring that research-oriented learning or a project-based learning in the campus, that would be great help to us to take the institution to the next level. So that's what I was requesting, Madam. So hopefully, Madam, we are expecting a positive reply from your side.
Thank you.
And we can have one more online meeting with our management, our chairman, sir, because he'll be very happy to interact with you and meet you. So if you permit and give your time, we can invite our chairman sir also.
Sure.
Yeah.
I'll convey it to Sarveshwar Rao garu.
Thank you, madam. Thank you so much, madam. Thank you.
So, madam, thanks for all, in spite of your busy
Thank you,
schedules.
Sarveshwar Rao.
And
All the very
you
best.
honored my request. I don't know how to thank you for that. And really, it's a very good blessing for our SDES, our educational society. And really, people have nourished and benefited the information you've given about this IPR, patenting, and people are hearing patenting. But you have given the complete life structure of patenting and the time bounds and all these things. I think they'll definitely derive some benefit out of it, and we expect similar support for future activities and programs. Anyway, thank you very much. Please convey my regards to Dr. Gokhale sir and my best wishes to Nihar.
Thank you. I wish you all the very best. Thank you very
Thank you.
much.
So,
May I take?
yes, ma'am.
Thank you.
Javed sir, you want to tell something?
Yes, sir. With the permission of the director, sir, I want to conclude the session. That's what I want.
Yeah, Javed Garu, you can conclude the session.
Yes, okay, sir. So I would like to thank our management, our chairman, sir, Shri G. Panduranga Reddy Garu, and our vice chairman, sir, Shri G. N. V. Vibhav Reddy Garu. And especially when I have contacted with our director, sir has accepted immediately to organize all these events. So I would like to thank our director, sir, Dr. M.D. Sameeruddin Khan Garu. And Sarveshwar Rao Garu, he is the important person. He spoke with ma'am, and ma'am has accepted within short period. Thank you, ma'am. Thank you very much for coming and giving your time. And thank you, Sarveshwar Rao, sir, for talking and taking this time. Thank you, sir. Thank you very much. Thank you, sir.
Tell us what you want.
And yes, sir. And the students, those who are made all the posters and the arrangements, the technical club or technical club students, I want to appreciate them. And in the future also, they will coordinate with us. Thank you all the students of technical club for supporting me in this event. And the head of the departments and the faculty, those who have joined here, and the students, those who have joined here. Thank you very much. I think you have learned a lot. Please have a use of it. And I would like to conclude the session now. Thank you very much, one and all. I'm concluding the session. Thank you very much.
Javed Garu, please send me the recording of this session.
Sure, sir. Definitely, sir.
Sarveshwar Rao Garu, thank you so much, sir.
No, sir, I am with you. Tell me what you want.
Sir, you are
You need to lift a stone. No, you need to lift a stone for the build-up of the institution. I am there with you. You tell me what you want, what stone has to be lifted. I'll lift it and build up the building.
Thank you, sir. Thank you so much, sir. Thank you.
Thank you, sir. Thank you very much.